Hello, everyone. My name is Benjamin Hsing. I'm a partner at McGuire Woods. I'm here today to talk about recent developments and trends in ANDA litigations. My practice here is primarily patent litigation in the life sciences space, and I've represented many branded pharma companies over the years, including Hatch-Waxman cases. So today's agenda is I want to talk about three main areas, which are the sort of hot button issues in ANDA litigation. So this is the agenda. First, I want to talk about venue in patent cases, Hatch-Waxman cases. You would think that since the Hatch-Waxman Act was enacted in 1984, almost 40 years ago, we should know by now where we can sue generic drug companies. But the Supreme Court's T.C. Heartland case in 2017 really muddied the waters quite a bit. And so for 5 years, where we can sue is quite unclear until recently, just last year, the Federal Circuit Valeant case kind of cleared things up a little bit. So I want to talk about that. And also, the next topic is induced infringement, particularly in light of the recent GSK case in connection with statutory carve outs that the generic drug companies often use to omit from its label a patent indication so that they can avoid infringement of the use patent. And so the GSK case raised a lot of issues about the continued viability of this statutory carve out mechanism. And finally, I want to talk about patent eligibility, which has been an issue for patent cases for quite some time since the Supreme Court's Mayo case. So first, venue in Hatch-Waxman cases. All right, so there are actually, if you're aware of civil litigation, there are actually two venue statutes, at least at one time, for patent cases. One is a venue specific for patents, which is 28 U.S.C. 1400, which basically says any civil action for patent infringement may be brought in the judicial district where the defendant resides or where the defendant has committed acts of infringement and he has a regular and established place of business. So before the T.C. Heartland case, the general venue statute, which is 28 U.S.C. 1391, was also applicable to patent venue statute. So in the general venue statute, an entity shall be deemed to reside in any place where the defendant is subject to personal jurisdiction by the court. So if you combine the general venue statute with the patent venue statute, it was very easy to sue a potential infringer. You can just sue this person or this entity wherever there's personal jurisdiction, because reside in the patent venue statute means where any individual entity will be subject to personal jurisdiction, which is defined in 28 U.S.C. 1391. However, in the T.C. Heartland Supreme Court case in 2017, everything was changed. The Supreme Court said the general venue statute did not apply to patent cases. So for patent cases, only the patent venue statute is applicable. And for the purpose of the patent venue statute, a domestic corporation resides only in its state of incorporation. So that changed everything. So now, under the patent venue statute, you can only bring a patent infringement lawsuit where the defendant resides, which means where the defendant is incorporated, or where the defendant has committed acts of infringement and has a regular and established place of business. All right, so that really drastically limited the places where the generic companies could be sued. So if the defendant is incorporated, let's say in Delaware, that's easy. You could sue that defendant in Delaware. What if the defendant is not incorporated in Delaware, and you want to sue the defendant where the defendant has committed acts of infringement and has a regular place of business? So what does that mean? So post T.C. Holland, what is a regular and established place of business? Well, the Federal Circuit explained in In re Cray that in order for a place to be a regular and established place of business, there must be a physical place in the district. Okay, so there's got to be something physical in the particular place for that place to be a regular and established place of business. A virtual space or some sort of electronic communication would not be sufficient. Okay, and also the place must be a place of business that is both regular and established. So something that's sporadic or temporary would not be sufficient. And finally, it must be a place of the defendant. So it's not merely the place of distributors or contractors or solely the place of an employee. Well, in the COVID world, a lot of people are working remotely. So what is a regular and established place of business for telecommuting or remote employees? Well, the key factors are, really whether the company owns, pays for, or rents the home. Okay, whether the employment is conditioned on employees residing in the district, that is, whose decision was it to conduct the activities in the district, and whether the company holds the location out to the public as its place of business. And finally, the nature of the activity compared to activity in other locations. So merely working from home, an employee's home likely would not be a place of business that would fall under this regular and established place of business criteria. The much more difficult question for Hatch-Waxman cases is, where is this act of infringement? Where did it occur? Okay, because under the statute 3521-271E2, it is an act of infringement to submit the ANDA, which is the abbreviated new drug application, to the FDA, okay, with the intent to market that drug. That is the act of infringement. Because in Hatch-Waxman cases, the generics have not marketed the drug. You're suing the generic before the generics are on the market. The generic drugs are on the market. So there's really no infringing product that is being sold at that moment. And the Supreme Court has described this 271E2 infringement as creating a highly artificial act of infringement because it permits an innovative drug company to bring suit before the ANDA filer brings its generic product to the market. All right, so there's nothing on the market yet, but already there is an act of infringement by the fact that the ANDA filer has submitted the ANDA to the FDA. So where does the infringement take place in this kind of situation? So since T.C. Holland, there's been two approaches. The first one is a retrospective approach, all right? And then you also have a prospective approach. So under this retrospective approach, a venue will be proper, perhaps will be proper, where the ANDA was prepared and was submitted, all right? Number one. Number two, the ANDA was filed with the FDA, which is located in Maryland, so perhaps Maryland would be an appropriate place. Others have argued where the paragraph 4 notice letter was received, that may be a place for a proper venue. And some others have suggested perhaps where the proposed generic drug batches were submitted with the ANDA was manufactured. So that would be the retrospective approach. And then you have a prospective approach, which looks to the future. So in this kind of approach, a district court may look to the future when determining proper venue. The argument goes like this. The Congress deemed the end of filing to have a non-speculative causal connection to the end of filer's future infliction of real-world market injury. Because once you file the ANDA, you're going to be marketing that drug, right? So the filing of the ANDA is actually connected to the future distribution of the drug product. So upon prevailing on invalidity or non-infringement, ANDA filer could distribute or sell the proposed generic products throughout the United States. So anywhere the ANDA filer will be selling or distributing the drugs will be a place where an act of infringement has occurred. So that's a prospective approach. And the Federal Circuit actually has taken a prospective approach to personal jurisdiction in ANDA cases. But we're talking about venue here, which is different from personal jurisdiction, of course. So what have the district courts done? So they were split on this issue. So for example, in the Bristol-Myers case, Delaware, 2017, there the court said that in the context of Hatch-Waxman litigation, the acts of infringement the ANDA filer has committed includes all of the acts that will constitute ordinary patent infringement if, upon FDA approval, the generic drug products launch into the market. Basically, the court is saying, I'm looking to the future. When the ANDA has been approved, where the generic products will be sold, in those places where the products will be sold, will be those places where the acts of infringement have occurred. Okay? And another court in the District of New Jersey agreed with this rationale. So that's the prospective approach. You look to the future to see where the ANDA filer will be selling the drugs. There's also the retrospective approach, as I mentioned earlier. So some district courts have adopted the retrospective approach. In the Galderma case, District of Texas, the court there said the Bristol-Myers Court's rationale, that's the prior decision that we just talked about, is inconsistent with the plain language of the statute, which does not identify any artificial act of infringement other than the ANDA submission. All right? So the court here said the act of infringement arises out of the preparation and submission of the ANDA. You don't look to the future, you look to the past to determine where venue is proper. That is where the act of infringement took place. And this other district court case, the Valeant case, agreed with the Galderma case. So here, the case said that the district court said it is undisputed that defendant Mylan submitted its ANDA application in West Virginia to the FDA in Maryland. None of these actions occurred in New Jersey. Accordingly, plaintiff has not met its burden of showing that an act of infringement occurred in New Jersey, which is necessary for the venue to be proper in New Jersey. So this district court took also the retrospective approach, and this case was then appealed to the Federal Circuit. So what did the Federal Circuit do? The Federal Circuit adopted the retrospective approach. Okay, so in this case, the Federal Circuit said that we conclude that in cases brought under 35 U.S.C. 271E2A, infringement occurs for venue purposes only in districts where actions related to the submission of an ANDA occur, and not in all locations where future distribution of the generic product specified in the ANDA is contemplated. So you look to the future, you look to the past to determine where the act of infringement occurred. And the rationale goes like this. The statute says past committed acts of infringement. So the Federal Circuit says this is a present perfect phrase, which counsels that the acts accused of infringement must have already occurred. So if you're going to be talking about selling the product, which will be occurring in the future, and that's not what the statute is saying, because the statute says has committed acts of infringement. And if you look at the statute itself, it says it shall be an act of infringement to submit an ANDA. It doesn't say it shall be an act of infringement to distribute an ANDA product in the future. The statute itself defines act of infringement to be submission of an ANDA. Now, of course, acts which are protected by the safe harbor provision are non-infringement for all purposes. For example, so if we were saying one of the possible scenarios would be where the generic batches were manufactured, that would be protected under 271E. So that would be not used in determining where the acts of infringement occurred. And then as to the suggestion that maybe District Court of Maryland would be appropriate because that's where the FDA is located, the Federal Circuit said, well, it may well be that the District of Maryland satisfies the test for venue that we have laid out here. We do not resolve that question. So the Federal Circuit left that question open. And then the Federal Circuit also said, we also do not define what all relevant acts involved in the preparation and submission of an ANDA might be, leaving those questions for other cases where the precise contours are presented and briefed. So there's still not a definite, clear direction from the Federal Circuit as to what constitutes submission of an ANDA, okay? Because the Federal Circuit is saying, we don't, let's leave that for a future day to decide. So where is the venue proper for Hatch-Waxman cases in light of T.C. Heartland and the Valeant case from the Federal Circuit? Well, number one, where a defendant is incorporated. You can always sue a defendant where the defendant is incorporated. Okay, that's true for all instances. And then you can also sue a defendant or generic drug company where it has a regular and established place of business and has committed acts related to the submission of an ANDA. Okay, so what does that mean? Acts related to the submission of an ANDA. It's not so clear because the Federal Circuit said we're not going to define the full contour of what this means. But the Federal Circuit does say the acts must be sufficiently related to ANDA submission. Acts will suffice to categorize those taking them as submitted as a submitter under 271E. So you have to be a submitter. Whatever acts will fall under the term will make you a submitter of the ANDA. Those will be the acts that will constitute infringement. So are acts related to just purely preparation of the ANDA submission? That's not so clear. Okay, and then in a lot of situations, you have electronic filers. So for example, a generic drug company may not actually be filing the ANDA themselves. They may hire a third-party vendor to do electronic vendor. So the generic drug companies may be located, let's say, in West Virginia, but the third-party vendor may be located somewhere, let's say, in Missouri. So where is the ANDA filed in that particular instance? It's not so clear at this moment. So all we know is the acts must relate to an ANDA submission in some fashion for that to be constituting an act of infringement. And finally, a foreign defendant for venue purposes, of course, can be sued in any judicial district. So that's kind of where we are in venue. I think at least we know that the Federal Circuit is taking a retrospective approach, so that dispute among the district courts have been resolved. So the next thing I want to talk about is induced infringement. All right, so induced infringement has become a big issue in light of the recent Federal Circuit GSK case, and I will talk about that case. So just to give you some background, there are two types of infringements. well, really more than two. I want to focus on two types. One is direct infringement. That is, if you're selling a patent invention which is infringing, you're offering it for sale, you're making it, that's direct infringement because you're actually doing it yourself. So that's direct infringement. So there's another concept called inducing infringement, which means under the statute says whoever actively induces infringement of a patent shall be liable as an infringer. So how do you induce someone to infringe? All right. So the Federal Circuit has said, in contrast to direct infringement, liability for inducing infringement attaches only if the defendant knew of the patent and the induced acts constitute patent infringement. So you have to know the patent, be aware of the patent, and then you have to know that the induced acts constitute patent infringement, which means there's an intent element to inducing infringement. As the Federal Circuit said in the Sanofi case, it must be established that the defendant possessed specific intent to encourage another infringement. All right, so in terms of Hatch-Waxman cases, knowledge of the patent is very easily proven because the generic drug companies have to send a paragraph 4 certification to the NDA holder or the patentee to certify that they don't believe, they either believe the patent's invalid or that they believe it to be non-infringed. So when you send the paragraph 4 certification, obviously you will be aware of the patent. Okay. Now in terms of the intent element, how do you prove intent for inducing infringement? The courts look to the label, all right? You look to the drug label to see whether the label would encourage somebody else to infringe the patent. So that's what the Federal Circuit said here in the Sanofi case. It says when proof of intent to encourage depends on the label accompanying the marketing of a drug, the label must encourage, recommend, or promote infringement. So this is particularly relevant in patents that cover methods of use. For example, a patent may cover a method of treating a particular kind of disease, because you have to, of course, the generic drug companies themselves, they're not treating the disease, right? They're only selling the drug, or they plan to sell the drug. It will be the physicians who will be treating the diseases, right? So technically speaking, the generic drug companies will not be direct infringers because they're not the people who are treating the patient. But they may be inducing infringement because by selling the drug and by having a drug label which promotes the treating of a particular disease by this drug, you're inducing the physicians to infringe the patent. So in patents that cover methods of use, the charges against the generic drug companies will not typically be direct infringement, but rather inducing infringement. So how do the generic companies avoid this kind of method of use patent? There's a mechanism called a statutory carve out. All right. So basically, a generic company can sort of modify its label. Usually, generic drug companies, they will copy the branded drug company's label, but the statute allows them to carve out, that is, to omit a patent indication. Okay. So a label may have several indications. One of which is protected by a patent. So the generic drug companies would then omit that patent indication from the label, thereby avoiding inducing others to infringe that indication, and thereby avoiding inducing infringement. Because the Federal Circuit has said that the inducement claim can support a Hatch-Waxman action only if the alleged infringing use is an FDA-approved use. So if you don't have it in the label, then you will not be inducing infringement. So this carve-out label is commonly called a skimming label, all right, because it's I guess, it's thinner than the real label. It doesn't have the patented indication. Well, that takes us to the GSK case. So that was decided by the district court in 2018. So let's go through the facts of this case. It's a very, very interesting case. So GSK markets this drug called Correct, which was approved for 3 indications, including congestive heart failure, CHF, okay? And there were 2 other indications. The only one indication, the CHF indication, was protected by a patent, namely this 069 patent. And GSK listed the 069 patent in the Orange Book. So let's go to the next slide. So in 2002, Teva filed an ANDA for this drug, carving out the CHF indication from the label because that was protected by a patent. And this skinny label was approved in 2007. At the time that Teva filed the ANDA, GSK did not sue for patent infringement. In 2003, GSK filed an application to reissue the 069 patent, meaning to correct the patent. There may be some errors in the patent, they corrected it. And then this patent reissued as the 000 patent, 2008. And there was no lawsuit. In 2007, Teva launched the generic drug product. And then in 2008, GSK decided to delist the 069 patent because that patent has been reissued as the 000 patent. So they replaced the 069 patent with the 000 patent. And that was 2008. And then in 2011, the FDA required Teva to add the CHF indication back to its label based on the delisting. So now the label has that patent indication, whereas when Teva launched the product, it had the skinny label, which did not have the patent indication. So now the generic label, Teva generic label, has the patent indication. So in 2014, many years after the issuance of the 000 patent, GSK filed a post-launch non-Hatch-Waxman suit against Teva. This is a non-Hatch-Waxman suit because the Teva's products are already on the market. So the product's already been launched, and therefore it's really technically not a Hatch-Waxman case anymore. So let's go to the next slide. So when GSK sued Teva, it sought damages for inducing infringement of really the 000 patent, which cover the CHF indication during 2 periods, right? There was one period where Teva had the skinny label, and then there was another period where the Teva's product had the full label, that is with the CHF indication. Okay, so the argument made by GSK was this. During the skinny label period, even though the label omitted the patent indication, some other language in the label that was still there still encouraged the doctors to use the product to treat CHF, all right? And also Teva was marketing its product to promote its product as being something that could also be used to treat CHF. For example, Teva marketed its product as AB rated to GSK Correct product without specifying that it was not approved for induced infringement because GSK had only marketed the Correct for the CHF indication. All right, GSK itself only marketed the Correct for the CHF indication. And then Teva said this product was AB rated, meaning equivalent to the Teva, to the GSK product, which means that Teva must have known or trying to promote its product for the purpose of having it being used for the CHF indication. So those were the arguments for the skinny label period. And then as for the full label period, well, that's easy, right? Because now the language regarding the CHF indications added back to the label, of course, that would induce others to infringe that particular indication. And the jury agreed with GSK and awarded $235 million in damages. And then what happens next? Interestingly, what happened next is that the district court then granted GSK JMOL of no inducement. Okay, so basically the district court overturned the jury's verdict. So what were the rationale for that? The district court said during the skinny label period, the Teva's skinny label did not instruct doctors to prescribe the drug for this CHF indication. Okay. What about GSK's argument? There was some other language that promoted use of this indication. The court said no reasonable juror could find that this LVD language, this other language, will encourage use for CHF. The court also said the AB rating does not induce infringement. The meaning of a AB rating means that the drug is therapeutically equivalent to a use that's in accordance with the label. So the label doesn't have CHF. So AB rating doesn't mean anything, all right? And then finally, the district court said physicians already knew how to use the drug at the time generics launched. There's no evidence that anyone relied on Teva's label in writing prescriptions. So that's for the skinny label period. What about the full label period where, the label had the CHF indication in there? Well, the court said for the full label period, there was no inducement either because there's got to be evidence of actual inducement. And here, we don't have any evidence that a single doctor was induced was induced by Teva's label. All right. So what about the Sanofi case? Remember the Sanofi case saying, if the label encourages others to use the patent indication, then there will be inducement. Well, the district court said the Sanofi case doesn't apply here because the Sanofi case involved the ordinary Hatch-Waxman cases, which deal in a hypothetical world where there was no product on the market yet. So for that kind of situation, you look at the label. But here, we're not in the Hatch-Waxman world. We're in the real world where the product's already on the market. So here, in a situation where the product's already on the market, you don't just look at the label. You need actual evidence of inducement. So you have to find actual evidence that a doctor or doctors actually relied upon the generic label. And here, there was no evidence of any doctor, relying upon the label, the Teva's generic label. So as a result, the district court overturned the jury verdict and Teva won before the district court. Of course, GSK then appealed the case to the Federal Circuit. So what did the Federal Circuit do? The Federal Circuit overturned the district court's decision. The Federal Circuit said the district court applied an incorrect legal standard. Okay, so President makes clear that when the provider of an identical product knows of and markets the same product for intended direct infringing activity, the criteria of induced infringement are met. So the court is saying, you look at the label, all right? The label promotes the CHF indication, and that is enough. You don't need some sort of actual evidence of inducement. That's not the law, all right? If you look at the third bullet here, the court said, President has recognized that the content of the product label is evidence of inducement to infringe. And the court also said there was ample evidence of other promotion by Teva of the CHF label. These includes promotional materials, press releases, product catalogs, so on and so forth. However, in this Federal Circuit decision, there was a glaring omission. You may recall that in the district court, there was a distinction between the skinny period, the skinny label period, and the full label period. And here, the Federal Circuit did not address the skinny label period and the full label period separately, because that should be important, because in the skinny label period, there was no language on language on the approved CHF indication, right? That was only in the full label period, as opposed to the skinny label period. So in the skinny label, Teva had carved out the patent indication. So did that label still induce infringement? What was the basis for finding inducement in the skinny label period? That was not clear from the Federal Circuit's decision. So when this decision came out, the generic industry protested heavily. It argued that this decision basically did away with the statutory carve out, because even if you carve out the patent indication, you can still be found to infringe based on promotional materials. And that should not be the case, argued by the generic drug company. So Teva filed a petition for rehearing en banc before the Federal Circuit. Teva argued that the panel's opinion nullifies the carve-out statute. Okay, it said Congress authorized carve-outs for a crucial purpose, ensuring that one patent use will not foreclose marketing a generic drug for other unpatented ones. Otherwise, a narrow method claim like GSK could block generics long after the drug itself goes off patent. So that was the argument made by Teva in the rehearing, in the petition for rehearing en banc. And GSK's response is this. GSK said, this is not a carve-out case, okay? Because Teva, even in the skinny label, still had language in there that promoted the CHF indication. So this is not a carve-out case. GSK is basically arguing that Teva never carved out the whole language that may have promoted the CHF indication. And then GSK also argued that substantial evidence shows Teva encouraged physicians to use the generic product in the claim in the patented manner. So what happened to this to Teva's petition? On February 9th, 2021, Federal Circuit issued an order. The Federal Circuit granted Teva's petition for rehearing, not a rehearing en banc, only rehearing by the same panel. It vacated the prior judgment and withdrew the prior opinion. And the panel limited the oral argument to the issue of whether the substantial evidence to support the jury's verdict of induced infringement during Teva's skinny label period, not the full label period. So the Federal Circuit granted the petition and listened to re-argument that was heard on February 23rd, 2021. But the issue had only to do with whether there was induced infringement during the skinny label period. So we'll see what happens. We'll see whether the Federal Circuit panel will revise its opinion, will add more clarity to what constitutes induced infringement during that skinny label period. My feeling is I don't think the panel is going to change the decision. I think the panel would add further discussion about the evidence that established induced infringement during the skinny label period, and so we may get some more clarity from the opinion, which I guess was soon issued since the re-argument was heard on February 23rd. So finally, I want to talk about patent eligibility. So under the statute, 35 U.S.C. 101, tells you what kind of invention would be eligible for patent protection. Okay, so the statute says whoever invents or discovers any new and useful process, machine, manufacture, or composition matter, or any new and useful improvement thereof, may obtain a patent, therefore, subject to the conditions and requirements of this title. But there are judicially created exceptions to 101. That is, to what could be patented. There's basically 3 exceptions. Laws of nature, right? You can't patent something that's a law of nature. For example, gravity. Everybody knows what gravity is. You can't patent gravity. That's a law of nature. You can't patent a physical phenomenon. Sun rises, in the east. That's a physical phenomenon. You can't patent that. All right. You cannot patent abstract ideas either. Mathematical algorithms, mathematical equations. You cannot, patent, for example, E equals MC squared. I mean, that's that's really more of a law of nature. So you cannot patent these things which already exist in nature, basically. So what does that have to do with Hatch-Waxman case? Well, quite a bit actually, at least in the biopharma space. These are the 2 key Supreme Court cases. One is the Myriad case, in which the Supreme Court held that a patent, you cannot have a patent to isolate a human gene because that is a product of nature. All right, so that really has to do with biotech cases. An isolated human gene could not be patented because that exists in nature. And then in another case that really has affected Hatch-Waxman cases somewhat is the Mayo case. In that case, the court said that a patent was not eligible for patent protection, even though it claimed a diagnostic method, because that patent covered a law of nature. Namely, there was a relationship between a drug metabolite level and the proper dose of the drug that was administered to a patient. The court said that relationship was governed by a law of nature and therefore was not eligible for patent protection. So, and then there was another Supreme Court case that was really not a life sciences case, but that case gave you the 2 steps that you must follow to determine whether an invention is eligible for patent protection. Step 1 is whether the claim is directed to a patent ineligible concept, namely whether the claim of the patent is directed to a law of nature, a natural phenomenon, or an abstract idea. All right, so if step 1 fails, that is, if your claim is directed to one of those 3 ineligible concepts, that doesn't mean you're not entitled to a patent. You go to step 2. Okay, so in step 2, you have to look at the claim elements both individually and as a whole, all right, to see whether when you look at them as a whole and individually, whether that transforms the nature of the claim into a patent-eligible application. And that step is called the inventive concept test. That is there something that's still inventive, even though the claim is directed to a patent-ineligible concept? So that takes us to the Hatch-Waxman world, where, as I was saying earlier, you have many patents out there that cover methods of use, methods of treatment. So one could argue that when you are treating a disease using a chemical compound, a drug, that is law of nature, right? Like, how does, for example, aspirin relieve you of your pain, of your headache? Isn't that law of nature, because aspirin is operating under some physical law that treats the disease that is alleviating pain? So that was the argument. So that leads us to the Vanda case. So here is a complicated claim, and I'll try to explain it to you. So this claim is drawn to a method for treating a patient suffering from his schizophrenia with this drug called iloperidone. So if a patient is a poor metabolizer for this particular enzyme called CYP2D6, there's a risk that this patient will suffer something called QTc prolongation. Okay, so there's some risk to administering this drug. So what do? So you have to determine whether the patient is this CYP2D6 poor metabolizer. So first you have to perform a genotyping assay on a biological sample from the patient to determine that whether the patient has a CYP2D6 poor metabolizer genotype. So you have to connect some sort of genetic testing first. And then once you determine that the patient has this genotype, you would administer this drug to the patient in an amount which is 12 milligrams per day or less. Because the patient is a poor metabolizer, you give the patient a sort of a smaller amount of this drug. But if you determine that the patient does not have this particular genotype, then you will then administer this drug to the patient in a greater amount. So basically, that's the invention, okay? And the argument was, well, that's a law of nature, okay? That was argued by the defendant in this case. The defendant argued there are actually two laws of nature. Number one being, there are certain patients have this mutation of this gene, which will make the patient either a poor metabolizer or not a poor metabolizer, all right, which that would be the second thing, whether the enzymatic activity would then affect the metabolism of this drug. So that's just law of nature. And then the patentee then, that was the argument made by the generic, merely added routine and conventional dose adjustment to reduce the risk of a side effect. And person of ordinary skill in the art would discover the invention in performing, your ordinary FDA-mandated studies. And finally, it was argued that the asserted claims are not different from the Mayo case. And that's exactly what happened in the Supreme Court's Mayo case, where the Supreme Court determined that this physical relationship between the amount of the drug in the body and the dose was governed by law of nature. The plaintiffs argue, no, that's not the case. We're not trying to claim the law of nature. We're not claiming that. And also our clinical study design, from which we were able to discover this invention was not routine or conventional. And then also the court said adjusting the dose for patients with these particular poor metabolism may not lower this risk in other situations. And the district court, following a bench trial, said, and the district court here was conducting this two-step analysis laid out by the Alice case in the Supreme Court. So in terms of step one, the court said the asserted claims are dependent on laws of nature. Okay, that's what the district court said. The district court said specifically the claims depend on the relationship between the drug, the enzymatic metabolism, and the resulting risk. So these are all related. Therefore, the claims depend on law of nature. However, in terms of step two, the court said the defendant has not proven by clear and convincing evidence that the precise test and the discovered results were routine or conventional. And the court said the dosage step was something that was not applicable to all of the patients, and the dosage step required applying genetic tests in a highly specified way. And therefore, if you look at all these combination of elements, it ensures that the claims amount to significantly more than just law of nature. So in terms of step two, the court said the claims passed muster, and therefore the claim invention was eligible for patent protection, did not violate laws of nature. And the Federal Circuit, the case was appealed to the Federal Circuit, and the Federal Circuit said, agree with the district court that the invention was eligible for patent protection. But the court had a different rationale. The court, under Alice Step 1, said the claims are not directed to patent being eligible subject matter. Okay, the court said, unlike the Supreme Court Mayo case, here we have a situation where the claims are directed to a novel method of treating a disease. So in terms of treating a disease, it is not subject to, treating a disease is not, according to the court, a law of nature. Okay, and therefore the invention is eligible for patent protection. And the court added, in terms of this invention, we're also treating the drug with specific dosages, and therefore the claims are a new way of using existing drugs. And the court emphasized, again, if you look at this slide, these are treatment steps, okay? And so the court seems to be saying when you are actually claiming a method of treatment, those types of claims will be eligible for patent protection. And the court does say the claims do include specific doses. But then after the Vanda case and other courts have sort of ruled that if you have a method of treatment claim, even without doses, those claims will be sufficient. And those kind of claims will be eligible for patent protection. And because the Vanda court already said on the step 1 that the invention was eligible for patent protection, the court never went to step 2. So in the Hatch-Waxman scenario, seems like when you have a method of treatment claim, those kind of claims will be eligible for patent protection. Whether or not you need to also claim specific doses, it's not so clear. At least other courts have said or suggested that even without doses, specific dosages in the claims will still be eligible for patent protection. So that takes us to the most recent case, the American Axle case, which is actually not a life sciences case at all. All right, but this case has created a lot of concerns with the biopharma industry because it may have a significant impact on biopharmaceutical patents. So this patent actually relates to a method of manufacturing propeller shafts for automobiles. So you have these shafts, they have liners which are designed to reduce vibrations transmitted through a shaft assembly. So what happens here is you insert these liners which are tuned to reduce vibration, okay? And that's the claim. That's the claim that was involved in this patent. You provide a hollow shaft member, and then you tune a mass and stiffness of at least one of the liners, and then you insert the liner into the shaft, and then the liner is then tuned. It's a tuned resistive absorber for these different vibration modes. Okay, so if you look at the patent, look at the claim, there's nothing about law of nature or mathematical equation or anything like that in the patent. All right. However, surprisingly, before the district court in Delaware, the district court granted summary judgment, holding that the claim as a whole were directed to the application of Hooke's law, and therefore the claims were ineligible for patent protection under 35 U.S.C. 101. All right, and the court said Hooke's law is an equation that describes the relationship between an object's mass, its stiffness, and the frequency at which the object vibrates. So the court said the claim's direction to tune a liner to weaken the different vibration modes amounted to simply instructing one to apply Hooke's law to achieve the desired result of weakening certain vibration modes and frequencies without providing a particular means of how to craft the liner and the shaft in order to do so. So the court is saying the claim amounts to nothing but claiming a natural phenomenon. And it's merely claiming a desired result. All right? And then as for step 2, the court said these additional steps were well understood, routine, and conventional, and therefore, even with these other elements in the claims as a whole will still not be eligible for patent protection. That was the district court's decision. And Federal Circuit, what did it do? The Federal Circuit actually agreed. Okay, the Federal Circuit said a claim to a method of manufacturing can be directed to a natural law, right? Claim 22, which is the claim at issue, is directed to a natural law because it simply requires application of Hooke's law to tune a prop shaft liner to dampen certain vibrations. The claim merely describes a result. It doesn't tell you how to achieve this desirable result. Okay, and in claiming a result that involves application of a natural law without limiting the claim to a particular method of achieving the result runs afoul of patent eligibility. And that was the majority opinion in this decision. And then the majority decision goes on to say, while American Axle may have discovered patentable refinements of the prior art process, neither the specifics of any novel computer modeling nor the specifics of any experimental mode analysis are included in the limitations of the claim. So basically, the court is saying you didn't claim enough, right? These other things which are necessary to achieve the result, you did not put them in the claim. In the claim, you only have natural law, and therefore your claim is not eligible for patent protection. Judge Moore dissented, and Judge Moore's dissent was scathing. She said, Claim 22 does not recite a natural law. Hooke's law is not mentioned by name or formula anywhere in the claim's specification or the prosecution history. There's nothing about Hooke's law in the patent. And Judge Moore went on to say, every mechanical invention requires use and application of the law of nature, or law of physics. It cannot survive to hold a claim directed to natural law simply because compliance with the natural law is required to practice the method. Basically, everything under the sun requires some sort of natural law. A method of treatment requires natural law, right? Any invention that you can think of operates under the physical laws of our universe, which is natural law. And that is what Judge Moore is saying. And if you're going to hold Claim 22 to being eligible, what's going to happen in the future? And this is the aftermath of American Axle. There was a petition for Rehearing and Banc that was denied by the Federal Circuit, evenly divided 6-6. And American Axle has filed a petition for cert before the Supreme Court. And many, many entities, interested parties have filed amicus briefs supporting or against the cert petition. The petition presented these two questions. What is the appropriate standard for determining whether a patent claim is directed to a patent-eligible concept under Step 1 of the court's two-step framework? Number 2, is patent eligibility a question of law for the court based on the scope of the claim, or a question of fact for the jury based on the state of the art at the time of the patent? The BIO organization, which is the Biotechnology Innovation Organization, which is basically a trade group, they filed a amicus brief in support of cert petition. And they argue, under the reasoning set forth in the American Axle case, literally any invention could be reduced to a natural law or abstract idea and thus held ineligible for patenting. For example, BIO argued, methods of manufacturing chemical compounds are all now at risk of being held patent ineligible. For example, when you make a compound, a chemical compound, or you combine one element with another element, come up with a chemical compound, that operates under some sort of a natural law as well. So what is the scope of patent eligibility? So we don't know what the Supreme Court is going to do. We don't even know whether the Supreme Court will grant cert. So this area remains in flux, we're waiting to see whether the Supreme Court will do anything about patent eligibility. So with that, I think I'm actually past my time here. If you have any questions, you feel free to send me an email, and I will be happy to answer them. Thank you so much.